Good afternoon.
Okay.
You might think after this court's decision in Gemidari...
Would you say your name on the record, please?
I'm so sorry. Yes, of course. I'm Mark Bennett, and along with Heather Lytle, I represent Mr. Alkayyali. You might think that after this court's decision in the Gemidari-Williams case, in which we raised unanimity but hadn't raised it in the Court of Appeals, that I would be fighting against an unbeatable force. However, the difference here is that we're not making a bare unanimity claim. If we were making a bare unanimity claim, the state, I hate to say unanimity, the state of the law in this court would be, well, you didn't raise it in the Court of Appeals, not only that, but you didn't raise it in the trial court, but at least the fact that you didn't raise it in the Court of Appeals forecloses it from this court. I don't think that should be the law, and I'd be happy to talk about why that shouldn't be the law, why this court should consider the decisions of the Court of Appeals in a broader sense than just the decision that the Court of Appeals made and the reason that the court made the decision, but it's not necessary in this case. Because in this case, one of the things that plays into the egregious harm is the lack of jury unanimity required on what are two separate offenses. B1 and B2 are separate offenses. They have separate elements. My brother from the state has said several times this is an element that was omitted. Elements belong to offenses. B1 is an offense. B2 is an offense. Texas courts haven't treated them this way for 50 years, if they ever did, but for at least 50 years. And because the jury wasn't told that you have to be unanimous on whether it was this sort of murder or that sort of murder, we have even more egregious harm than if they had been. Because, of course, if they had been told that, then we would know that they made a unanimous decision on...
So this calculates into the part of the egregious harm analysis where we look at the entirety of the charge.
The entire jury charge, exactly, Your Honor. So that's why unanimity is important here, because the entire jury charge is flawed, and it's not just flawed in that this element of B2 is missing, but also in that the jury isn't told you have to agree unanimously. And so we have this situation where we don't know whether there was one juror on that jury who did what juries are supposed to do and read the jury charge literally, word for word, hyper-literally, and then followed it. Because that's what juries are supposed to do. They're not supposed to be, oh, I get the vibe from the charge, and the vibe of the charge is if you kill somebody, you murdered them. It's these are the words, these are the steps, and this not only is it what we tell juries they're supposed to do, but it's what we should expect juries to do. We shouldn't have to guess at what the jurors' common sense of what murder is. Common sense is sort of this, common sense is something that people invoke when they don't have reason and facts on their side. If you ask somebody, why is this the case, and they say it's common sense, okay, what are the facts? What's the logic? What's the reason behind that common sense? And so when the state invokes common sense in favor of their interpretation of the jury charge, they're saying, well, yeah, this is vibes. We're going with our vibes, and we should let the jury go with their vibes, and we think the jury's vibes would be not to follow the literal language of the jury charge. We mentioned Niles, 2018 case. A missing element is not automatically harmful. And in this case, I think that's applicable because we don't have the bare unanimity claim. In the bare unanimity claim, if a jury is not required to find an element unanimously, that I anticipate is eventually going to be structural error. There's not going to be a harm analysis.
Wait a second, let me make sure I understand. Are you saying that we consider unanimity as part of the egregious harm analysis? Or are you saying that this is a separate claim that amounts to structural error?
I'm sorry, I confused the issue by adding in that lagniappe there about unanimity. What I'm saying here today is that unanimity is part of the harm analysis in this case. But however, because in a bare unanimity claim it would be structural error, it militates in favor of that being the deprivation of a fundamental right? And if you look at the entire jury charge, and the jury charge deprives the defendant of at the error that that was brought up on appeal, and the jury charge deprives the defendant of his fundamental right to unanimity, then that's got to be at least egregious harm. If it would be structural error in a bare unanimity claim, it's got to be at least egregious harm where it's incorporated into the jury charge, and that's the context in which it's brought up.
Has the Supreme Court of the United States ever said that the failure to include a unanimity charge is structural error?
No.
Wouldn't that mean that under Kane it is not structural error in our court?
Yes. And I say that I anticipate that it's going to be structural error. The law on this, of course, is new. The court knows that it was in 2020 that the U.S. Supreme Court held that unanimity under the Sixth Amendment applies to the state courts. The whole body of law is going to be fresh and new. And yes, of course, it's going to be decided by the Supreme Court. And until it's decided by the Supreme Court, I suppose this court is going to be bound to say, well, it's not. They haven't said that it is, so it's not.
But it plays into the harm analysis anyway.
Sorry?
It plays into the harm analysis anyway.
Plays into the harm analysis anyway. And also, I would add that it's so analogous to not telling the jury that they have to find proof beyond a reasonable doubt. That not telling them they have to be unanimous is so like not telling them they have to find proof beyond a reasonable doubt that it's hard to see how you distinguish the one beyond a reasonable doubt, which is structural, from the other unanimity eventually.
I have a question. I'm sorry. This may sound somewhat like preaching to the choir here, but I'm curious about this idea that we can have jury charges that don't require juries to find the elements of an offense, and that's just kind of their circumstances when that's okay. And here's my follow-up to that is, if we can have a jury charge that leaves off one element in requiring the jury to find that, how many elements are too many? And have we ever really wrestled with that? Because what if a jury charge, for example, says, now therefore, if you find, right, you will find the defendant guilty.
Right. Or,
I mean,
right,
is that,
right.
could it be we have a case where the evidence was just so overwhelmingly compelling that the Court of Appeals could just say, yeah, who wouldn't have found guilt,
I'm going to leave that to Mr.
Okay.
Messier to answer.
Right.
Of course. I mean, there has to be a line drawn. There should be a bright line drawn. And if you're going to draw a bright line, the line should be the elements of the offense. That's where because if you say it's okay, if you say it's okay not to ask the jury about one of them, why not say two of them, three of them, four of them, and where do you stop?
Well, I was going to say, though, the Supreme Court, to build on what Judge Keller said, the Supreme Court has said that leaving an element out of the jury charge is something that is subject to harm analysis over vociferous dissents. They make a great case for doing it. I totally understand it, but they've said that it can still be subjected to a harm analysis.
Yes, yes, and I would distinguish that from having an element missing and also not telling them that they have to be unanimous on whether it was one offense or not. Yes.
And we are a separate sovereign, too. Yeah.
Pardon me?
We are a separate sovereign in Texas.
We are, and we should long remain that way. Unless the court has further questions, we pray that the court affirm the judgment of the court below. Thank you.
Thank you, counsel.
May it please the court. This court faced a similar situation in Galenas, I think it's pronounced, a couple of years ago, where the application paragraph for 3823 instruction was clearly wrong. It said the opposite of what it was supposed to, and the abstract said exactly what it was supposed to. And this court relied in large part on common sense to conclude that the jury was not going to be misled, and I'm hoping it did that not because it didn't have anything better to rely on. I think common sense is one of the things we have to use when we look at what the jury did, when we're figuring out what a hypothetical jury would have done. And in this case, to this point, I've been content taking the appellant's version of events and using it for whatever it is. It just doesn't raise causation. But the uncontested facts, the physical facts, show that it wasn't a simple matter of he put his hand intermittently over his wife's mouth and she had some sort of cardiac event that he doesn't want to be responsible for. Her mouth was filled with what they call frothy sputum. It's the sort of frothy, bloody substance that you get when you cough up from your lungs when you can't breathe for an extended period of time. Underneath her scalp, she had petechia, burst blood vessels that you get when blood flows into your head but can't flow out of your head. And you get that from squeezing around your carotid artery. Now, maybe jugular vein, I'm sorry. Vein will take it back to your heart. So she has real physical evidence, not only of a struggle, but of a struggle that impeded her breathing and impeded her circulation for long periods of time. His story is not believable on its face. But even if you take it at face value, you still don't have a causation argument. And I still have not heard opposing counsel explain how when you run the steps of 604A, you get a concurrent cause problem. And maybe it'd be helpful to look at this from a situation where, I mean, in this case, the jury was instructed on concurrent causation. We have to assume that they rejected it, that they understood it and rejected it. If they hadn't been given the instruction, if we do something closer to Sear, where the defense asks for a concurrent cause instruction and doesn't get it, we would run through the evidence and we would ask, okay, what is the concurrent cause here? What is the cause that's clearly sufficient to cause her death? We don't have any testimony that would support her having a freestanding heart condition that would cause her to just snap, have a heart attack, and die unprovoked. There's nothing. There's his claim that she faints. She has a repaired heart, she had a small heart defect, congenital, that was repaired 5 years prior.
But there's evidence other than his that she fainted at her wedding, right?
Yes, everyone agrees she fainted on her wedding day. He says she faints all the time. No other family members are aware of any other fainting.
Does the autopsy, I assume there's autopsy evidence in the case. Does it confirm that there is a heart issue?
There is nothing found on the heart. The repair to her heart was intact.
But there was one. There was a repair that was done to the
Yes, 5 years prior, and they said it was intact.
So that somewhat corroborates the fact that he said that. I mean, he's not the only person who suggested that there might be something going wrong with her heart.
The best, well, no, because she had an EKG the year prior. She had gotten to the point where doing her regular checkups, they told her she didn't need to come back anymore because everything was functioning the way it was supposed to. What opposing counsel tried to get, trial counsel rather, tried to get through cross-examination of the state's expert is that this repair is somewhat close to a node on the heart that might affect heart rhythm. And the best they could get was, well, yes it is, and I guess maybe it could, except her EKG from the prior year showed no problem. And also, you don't get sudden drop dead. This is the sort of problem where if she has dysrhythmia, she starts getting tired. And it takes hours, and you would get to a hospital before then. You don't just suddenly faint. And all the things that were hypothesized by trial counsel, the state's expert explains, all of these things can be exacerbated by stress or brought on by stress. So you have no evidence that she has a freestanding heart problem that's going to cause her to just up and die. And you have no evidence that assaulting somebody who allegedly has a heart condition is clearly insufficient to trigger a cardiac event. So I'm sorry, Ron.
No, I was just going to say, these are all very persuasive arguments, but the flip side of that argument, though, doesn't it make it more important to make sure that the defense has the ability to argue whatever possible defense that it has? You're kind of pointing all these facts that show that this was not necessarily a contested issue, but the only thing they had was to try and create reasonable doubt from these other facts they're pointing to.
No, that's the only thing. Not only is it not the only thing they had, the thing they did have and did use is the intent argument. And the reason I'm framing all of this as a hypothetical request for a concurrent cause instruction, if you treat it like a defensive issue, you'd run the analysis from Sear. You'd look at this and you'd say, the lack of any evidence that what this heart condition was clearly sufficient, and the lack of any evidence that what you did is clearly insufficient, we would say, I think this court would say, you're not entitled to the instruction. And if you're not entitled to the instruction, then causation is not legally an issue. And so that should end the analysis.
So the fact that he called 911, you would say goes to his intent to kill her, not to causation. I mean, it doesn't have bearing on causation?
He doesn't call 911 until he calls his coworker. He's upset. He says, he curses a little bit, but he's like, I messed up. I hit my wife. She's not breathing. I'm so screwed. I'm going to jail for the rest of my life. And coworker says, you should go home. You should call 911. And so he does that because he's now told somebody. She called 911 because she wasn't confident he would. He'd also confided in her again about all the problems he'd had with his wife and his thoughts of violence towards her. So again, he's not entitled to causation on his version of events. I believe everything he tells you. But the harm analysis has to take everything. And this was not a causation argument focused on B2.
Well, counsel, what about Ms. Lytle's point, but the fact that you have an indictment that was flawed So you start off with the jury having the wrong framework, and then they end it with the wrong framework. So they're viewing it this entire time through the wrong framework, and then at the very end, again, it's reinforced in that jury charge.
Except that reading the indictment at the beginning of trial and reading the application paragraph at the end of trial aren't the only two things that happened. They voir dired properly on having to cause death. Opening statements were properly on causing death. The conversation through cross-examination was causing her death. The closing arguments were causing death, and the abstract from B2 and all the abstract and application paragraphs for all the other homicide charges were correct. So viewed totally, it was drilled into their head that this is a murder case, or with a lesser included, a homicide case, you gotta cause death. So notwithstanding those two errors, I mean, the last error is why we're here. The other error was forfeited, and again, I would say everybody knows it's supposed to be there, and nobody was actually contesting it. That's why there wasn't an objection in either case. All right, thank you.
Thank you, counsel. The case is submitted. Let me just explain for a moment. We're going to adjourn the court for 5 minutes, step out, come back in, and have an informal session where the judges will have a few comments, and then we will have a short Q&A.
We all do moot court at UNT Dallas.
Okay. Well, I mean, I've done this is my 25th in front of the CCA, and I've done another 20 for it. So this is just timing.
Oh, yeah. Oh, okay.
Don't look into my application.
Okay.
I don't think that was 5 minutes, but we decided to come on back in. I have notes here somewhere. I wanted to start out by thanking everyone for coming. There are a number of people that have worked really hard to make this event come together, and the court wants to acknowledge them, and it is a lot. So I want to thank the University of North Texas College of Law, SMU Dedman School of Law, the Dallas Bar Association, the Criminal Justice Section of the Bar, in particular Justice Whitehill, Judge Moorhead, Stacy Sewell, Jennifer Tharp, Kenda Culpepper, Phil Mack, Bill Matea, and Rob Kanyas. All of these people work together, and there's a lot of organizing to put something like this together. We had a nice tour, really fantastic tour at University of North Texas College of Law yesterday of a JFK exhibit in the municipal courts building where Lee Harvey Oswald was shot by Jack Ruby. It's very cool. And we had a really nice dinner that everybody enjoyed last night too. Our clerk, Dina Williamson, has done this a number of times, and I would say she has it down to a science, which means that I don't have to do it. And our Judge Kevin Yerry was our liaison for this event too, and they both worked really hard to make it come together. The attorneys I want to thank first for being willing to argue here, and second for doing a really fine job. I know these attorneys, most of them, and I knew they would do a good job, and they really did, so I hope you enjoyed that. They did an excellent job, and they're excellent attorneys. And I also want to thank, I can't remember his last name, Rusty from the DA's office, who was supposed to argue and volunteered to reschedule his argument so that we could have these two arguments today. And I want to thank you, the students and the attorneys, our families and our friends that came, for joining us today. And we hope that this has been an educational session for the students, giving them a look into the window of their future. And we want to really congratulate you on the things that you've done and wish you the best of luck in your future as a lawyer. We're going to have a short question and answer. If anybody has any questions, we won't talk about these cases. We won't talk about the facts or any other aspect of them. But typically, there are questions about how the court operates or, in general, the kind of things that we do. For instance, we have oral argument away from Austin at least once a year, sometimes twice a year. We've done that since the first year I was presiding judge. We came to Dallas, and we had argument at SMU. We came here to this very room again about 15 years ago. And I will say that the program has developed in a very good way since that first episode at SMU, where we really didn't know what to expect and what to do. But we always enjoy these programs and look forward to doing them in the future. So, any questions? Yes.
Very painfully.
Does anybody else want to answer that question? Besides Judge Newell, or is that sufficient?
Basically, what we'll do after this, we will have like an informal sort of vibe session, maybe. I don't know, but we'll sort of feel each other out. We'll sort of get a sense for where we think the court is going to go, and then based upon that sort of preliminary vote, we'll assign it to a judge who's next up on the rotation, and they'll write a draft, and that will be circulated to the rest of the court. Then we'll bring it in on Tuesdays. We have conference every Tuesday of the month. Occasionally, we will take a break off for holidays or something like that, but generally every week we meet and we discuss opinions. In order to not lose our minds, we limit the number of opinions you can talk about, so it's on a schedule. But then once the draft comes in, we'll talk about it, and we'll hash out the different ideas. And if someone wants to write a side opinion, they may pick it up for time to write a side opinion, to either concur, dissent, or when I say side opinion, and then see if that changes the vote at all. And that process goes on through 3 different opportunities to pick the case up, and then if everyone has a settled idea, it goes out the door on Wednesday on our handout. So, no, thank you. Good question.
Yes, ma'am.
Before you've ever gotten to oral argument, you've gotten extensive briefing from the parties. How much of a difference do you find that oral argument makes and how, as opposed to just the briefing?
Judge Erie?
So I think we have some differences of opinion about that up here, but to me, it's a huge part of the process, you know. And there's some people that will argue, well, it's never made a difference to me, you know. But I do think it makes a difference. It certainly has more capacity to make a difference the way this court operates than it does, I think, maybe in other courts, because as I understand it, many courts of appeals, by the time they get to oral argument, already have a draft opinion. You know, they've got a lot of momentum in one direction or another, whereas this court, at that point, the point of oral argument, has only made a decision about whether or not we should decide the question, right? We haven't really dug in on the merits yet. And so typically when we hear oral argument at home in Austin, immediately after the arguments are over, we go up to our conference room and talk. And it's been my experience that many times we're talking about what those lawyers said, you know? So you can decide for yourself whether you think that might have any influence on the outcome of the case. But it certainly is a moment, this thing we do here, this dance with the lawyers, where we get to have an exchange of ideas that's different than the kind of exchange that happens, you know, in a text that we can take home and read at our leisure. And so, you know, things happen sometimes, and those things that happen help us to see things maybe that we might not see from just reading the written word. I think it's an invaluable part of the process that we should never completely let go of. I mean, there are cases that can be decided without it, certainly. But that's my response.
Yes. Could you speak up just a little bit, please?
Rock, paper, scissors.
That occasionally happens, and when it has happened, we just work it out, one way or the other. I mean, we don't get another judge appointed or anything like that. We just figure out how to handle it on an individual basis.
Although, if we were at an impasse, we could ask the governor to appoint, but we've never had to do that.
Well, if we were at an impasse because one of our judges was constitutionally disqualified, recusal matters don't allow us, it's my understanding, to ask the governor to appoint a new judge. Yes? An hour total? Well, somebody else want to answer? I don't want to hog the microphone.
Whether we ever extend the period?
No, the question is whether an hour would be better. We often extend the argument. I mean, we routinely allow attorneys to
Yeah,
talk
we did that. Yeah, we did that
beyond the
today.
limit. Yeah.
I mean, yeah. I would add, I got the chance, maybe you remember, we had a very lengthy argument in the Perry case where we gave a lot of people a lot of time. And I don't know that necessarily helped. I think that it was maybe a little bit more, it was good that we sort of said, we're gonna make sure that we're not trying to cut anyone off or anything like that. But the truth is, I think that Presiding Judge Keller does a really good job of sort of making sure that we don't just arbitrarily cut the people off. We'll let people ask, if judges want to ask questions, we can continue things going. And so we take as much time as we need, even if we've got a guideline that sort of tells us when to stop.
Okay, we've only had questions from one side.
There's one over here.
Okay.
Yeah.
Yes.
Hi, my name is Prisha from 1L at UNC Dallas School of Law. I was wondering how you decide which cases you want to hear. Are there things that you're looking for that kind of stand out, what that process looks like for you guys?
Anybody else want to answer that?
I don't want to speak all day.
Go ahead.
Somebody else.
We roll dice.
I guess the simple answer is for people four of us decide that we want to hear it. I mean, that's that's the most simple answer. I guess a more complicated answer is this something that the courts of appeals are either confused about, or the Beaumont court and the El Paso court have two different ideas, or it's a super important issue that we think needs to be addressed. So, I mean, that's the longer answer, I guess.
Yeah, I think I would add to like the reasons for granting a review are actually listed in the appellate rules of procedure, and that's really, while we don't necessarily formally go, is it this rule or is it this rule, we generally tend to gravitate around those ideas, a conflict, a new interpretation of a statute, a constitutional issue, or the Court of Appeals just was so far out there on a case that we need to sort of give them guidance.
Whether it's published can make a difference.
Yeah.
Mr. Bennett, did you have a question?
Do you ever have horse trading on granting review where somebody says, I'll agree to grant review on that one you're interested in, if you'll agree to grant review on this one I'm interested in?
Only on your cases. No, no.
The other way in my cases.
I don't remember us ever doing anything
I've
like
never
that.
seen
I don't
that
think we do that. I think we look at whether, can't speak for everyone, but we look at whether this is an important issue, it's the kind of thing that's recurring, and we have to address it. There's plenty of times where we're like, oh, I don't want to do that, but we should,
Also, if the court doesn't want to grant review on a case and we feel strongly enough about it, we can dissent to the failure of the court to grant review. So, I mean, there's always the option of saying what you need to say. You don't have to get review. If you're going to get voted down anyway, you can still say what you need to say as a judge.
Yeah, and
which is
sometimes,
nice.
sometimes that's persuasive and persuades enough judges to grant review, too. Any other questions? Yes.
Sorry.
Yes,
It's
ma'am.
okay.
So we have a lot of law students here. For any law students who might aspire to one day sit for your city, any advice that you all would like to share with us?
work on writing. I mean, legit, I tell that to people even before they go to college. I think that being a good writer is a very, very important thing, particularly for any area of law if you want to be successful, because it really teaches you how to organize arguments and thoughts, and it translates to a whole bunch of different things. But so much of what this is, oral argument is great, it's really interesting, but it's the tip of the iceberg. There's so much writing that goes on in our job and in this thing, and reading and things like that. So being able to analyze text is really a significant thing.
Ms. Williamson, did you have a question? Oh.
Like an auction, don't raise your hand.
Sold. Any other questions? All right, well then, thank you again for...
Can I say something real quick? We do have a couple of our law clerks here from the court, and so if there's students who are interested into an insight as to what it's like to be a law clerk at the court, we've got a couple here. Can our law clerks stand up?
Please stand.
Okay. Yeah. So if you have questions about what it's like to be a law clerk coming right out of law school, then these are the folks that you would like to talk to, Meredith and Seth, and so that would be a good resource for y'all.
Yeah, I guess as a follow-up to your question, I think clerking positions are overlooked sometimes by some law schools. It's a great way to start your career. It really is.
Anybody else?
Way in the back, in
Yes.
the red.
Be clairvoyant.
Avoid ruling on objections. No kidding.
Make sure that you check your public safety reports.
Yeah. I remember when I was a prosecutor, and I would get annoyed that when the judge would not make a ruling, and now sitting here, I understand why judges don't make rulings. So move along, or can we do something else? I mean, it's really hard to get reversed for not making a decision. No, but I guess my serious advice probably would be make sure the record's clear. The example I always give and I'm sure you've been through this, is you've gone through a trial, it's time to talk about the jury charge, and it's 7 o'clock at night and everyone's hungry and tired, and you have some off-the-record conversation for half an hour about it, and then everyone immediately forgets what you talked about, and then the next morning none of it's in the record because it was all off the record. So that's probably my biggest piece of advice, is just make sure if you are going to make a decision, make sure there's a record of why you're doing it, and so that way we can at least see why you did what you did.
I'd also say, based on a story I heard last night from Kenda Culpepper, be careful about who you hold in contempt and put in jail.
I would also say, just watch the jury charge. If you have a prosecutor who's preparing your charges, or even a defense attorney who's preparing the charges, I would double check it, because jury charge issues come up a lot for the court, and so just double checking that charge and asking questions about the charge to make sure that things are in order is probably a good idea as well.
You saw an argument today about a jury charge issue, and I mean that it lends itself well to, because it's something that can be raised without an objection, so they can always raise a jury charge, and it's also a purely legal issue, which appellate courts have more leeway to answer. So jury charge is a very, very big deal. Always check that.
So one piece of advice I got when I first became a judge from another judge friend of mine was, there are 4 things you can say on the record, and you should just stick to those, and that's granted, denied, sustained, and overruled. Don't say anything else.
There's a hand that went up in the back, again, on the back row.
I'm hoping somebody else could hear you, because I couldn't hear you. The timelines for what?
The timeline, like, does the procedural, if I understand you correctly, does the procedural posture of a case affect how quickly we move on a case, or what the procedural timeline, the timeline is for us to address or move the case out? Yeah.
Sometimes there's going to be an execution. We got to act, so.
Yeah, but as far as briefing, as a matter of practice, we allow a lot more time for briefs in death penalty cases, usually around 6 months instead of 30 days. So, again, that's a matter of discretion. But yeah, it takes a longer time. It takes a longer time to write a death penalty opinion and get an opinion out on a death penalty case, because the record is so long too.
Do we have a deadline when we have to get it out?
We have a deadline that we report to the legislature. We don't have to get it out by then, and sometimes we do it faster, sometimes we do it less fast, but we do have, not statutory, we do have guidelines that we report to the legislature, and then we report back how well we've met them.
And I would add too, particularly with death penalty cases, one of the things that doesn't get seen a lot, but it's something that goes on, is that the records and the points of error are large. They have large records, they have many points of error, and a lot of times the advocates themselves are not asking for more time to address these things, which is one of the things that ends up. Now, there are procedures for death penalty cases that allow sort of the direct appeal and a writ of habeas corpus to go on at the same time that tries to speed things up, but there's a lot of sort of practical aspects to those cases that end up requiring them to take a lot more time. And the issues are a lot more complicated too, which also adds to the difficulty in addressing those cases.
Yeah, it's not uncommon it takes 6 months for a court reporter to get a record ready, or, before it ever gets to the briefing stage. It should take months and months.
Also, in death penalty cases, of course, with death penalty, death is final. So we try to make sure that we look and examine very carefully every possible issue in those cases, and the records are voluminous because you've got individual voir dire in those cases. So instead of a panel, there has to be an individual voir dire of every single potential juror. And so if there's an issue with a juror, we have to look at all of that. So it definitely takes a lot more time in the death penalty cases. And then, as you've heard, some of the issues we deal with are so complex, it just takes longer to decide these issues, and then other things go into it that can take some more time. We do have accelerated appeals on some things, and so we do our best to dispose of those as quickly as we can. If it's a pretrial issue or things like that, we'll try to address those as fast as we can. And then we do set deadlines for lower courts to get things done so that we can keep a case moving.
Thank you. All right, yes.
So the first thing is you have to ask for it, right? I mean, my usual default is if somebody has asked for oral argument, my vote is to grant oral argument. And it takes 3, so you got to persuade 2 more then, right? There are, like I said though, there are some cases that really, they don't need it. And I understand why my colleagues sometimes think that. But I wish we would do more, so. Ask for it is the first thing. And I think the court would, maybe the court, you can try things. I know other judges from other courts have said things to me like, well, if they're trying to get board certified and they need to have some arguments, they put that in their brief. And so you can see in the part where they're talking about their argument that they need to have an argument. And that might make a difference, but I can't speak for anybody but myself on that.
That hasn't happened in our court yet. I would say if you can be specific about how oral argument would help and concise, that might get you a vote or two.
Yeah, make sure that you put, obviously you need to make sure you put it on the cover of whatever brief you're saying, but there's a statement, there's a requirement in the briefing that allows for a statement for you to explain why it is you want oral argument beyond just simply saying it would be good. I actually took some time when I was an advocate. I would write out things for why it is, and I've read those and I've been persuaded by them. The things that I look for are things that some tangible way that you can express to me why it is discussing this case in person is going to help us understand nuances to a particular legal issue. But if you're doing, like if you try and say that, and you got to consider your credibility, but you're trying to say that on like say a legal sufficiency issue, where then you may not get it. It's like we don't want to come in here and have oral argument and go, well, if we just look at the record, we'll totally we understand it. And so like that's the kind of vibe, or to go back to the vibe thing, that's the kind of thing that you want to be looking for, is just something that says, look, this is a case that will actually help the court discuss particular legal issues, and you're not going to come away from this going, well, all I need to do is, this is a dispute about what's in the record, and I need to read the record, and therefore we can answer it once we've done that, So that's the kind of thing. And I drilled down back to the idea for reasons for granting a review. Those things should inform you, about that, because is this an issue of first impression? Is this something that is the kind of thing that is a burgeoning issue on the national scene? Is this something where this is conflicting with a particular text or something like that? But these are the ways that you can embellish your pitch for argument that makes it stand out.
Okay, unless any of the judges have anything to add, we're going to conclude this session, and we will have about 10 minutes to visit informally with y'all. Do you want to take off our robes? Yeah. We'll go back, take off our robes, and we'll be back in just a few minutes if you want to stick around and have a little informal conversation.
Pictures of our very gracious judges for today. So get your little iPhones and whatnot.